Hello, hello. How are you guys? The day has finally arrived. Mike. Guess what day it is? Hump day. Good afternoon, everybody. It's so good to have you guys here. Thank you so much. Shout out to Tanika's 2 cents because thank you for recommending me because I've had people come in the comment section saying that you sent them over, and I want to thank you for that. That's fantastic. If you guys haven't seen Tanika's 2 cents channel, I recommend it. She did a dramatic reading of Sarah's letters, and as you know, your girl loves nothing more than a dramatic reading. And Tanika does a very good job. I thought it was funny. So thank you for sharing me out. I appreciate it very much. All right, today's the day. What do you guys think? Will the interrogation video be suppressed? Will it come in? I'll say this. It's just my opinion on it, and you can take it for all that it's worth. Remember, I'm not an attorney. So it's just a regular, it's just my opinion. But I think that it's not going to be suppressed. Even if the judge, I think even if the judge was going to entertain the potential for suppression, that motion doesn't have in it what there should be in it. And it was filed late to begin with. And so I will see how it goes, but I don't think it's getting suppressed. Also, I don't know if you guys noticed, but I added a little something to the intro at the beginning. And I remember I was telling you guys how the outro, there was a part in the outro that was bothering me. And every time I saw it, it was just like one of those things that I kept seeing it, and it just was like, I don't know, it was driving me nuts. So I fixed it. And so if you guys hang out until the end of the stream, then you can see it. Now, while we wait for the hearing to begin, we have, that was filed yesterday, we have a notice of provisional witness list, and there's comments that says fourth amended witness list. So let's see what this is about. This is just letting, comes now the defendant buying through the undersigned counsel, yada, that they've provided the fourth amended witness list. The undersigned counsel will electronically serve at the end of the day upon the office of the state attorney a list of names and addresses of persons known to the defendant to have information that may be relevant to any offense charged or defense to, or any similar fact evidence to be presented at trial under, and then the criminal procedure code. Let's see, what's this? This is another notice. The state of Florida, by and through the undersigned assistant state attorney, and files this notice of provision of supplemental witness list, certifying that on the date of the filing, the instant notice of provision of supplemental witness list, the undersigned assistant state attorney electronically served upon the defendant a supplemental list of names and addresses of persons known to the state of Florida to have information that may be relevant to the offense charged or any defense thereto, or to any similar fact evidence to be presented at trial under the same code. So that is that. Then we have the hearing and then the trial. Wow, this is crazy to me. I can't believe the trial day is finally here, because usually by this point, an attorney has said, you know what, I'm out. I'm going to file for I'm going to file a motion to withdraw, So I am super optimistic, cautiously optimistic that that the trial will be on time as scheduled. Now, I want you guys to know that for the trial, I will stream every single day of the trial. We'll have 2 sessions, okay? We will have the morning session, right? Which will probably start, I think 8 or 8:30, I can't remember. But you'll have plenty of notice. And then they'll have lunch. So we'll take that hour, and then and then we'll do the afternoon. Okay. Now, I want you guys to know that there's another trial that I'm quite interested in keeping up with. And my good friend, Alex Erickson, who has a fantastic channel that I highly, highly recommend you check out. She is going to start to cover all the things that you need to know before Leilani Simon's trial, which her trial, I believe, is scheduled to start October 10th. I think that's the day. So, I'll be over there and stuff, and she'll be over here. And because we both we followed the case all the way, and but I have followed Sarah Boone's case for 4 years at this point. Okay, babe. All right, Allie. Thank you for doing that, by the way. I appreciate that. Give her the what for. But I know that Allie talked about covering Leilani's trial, and I'll be busy with Sarah Boone, but we will definitely work together on both. I'll of course have Allie up. She knows she can come up anytime she wants to. My panel is always open for Alex Erickson. And so, yeah, so that's what we're going to do. Let me get over here to the YouTubes. I have spruced up the old background for Halloween. I love Halloween. It is my favorite holiday. I think that I like Halloween maybe like 3.5% more than Christmas. I like Christmas because I like to give the gifts, right? I like to wrap, and I like to see, the look on somebody's, the person's face when they get it. And I just, when that you bought them something that they really, really wanted, or you see something and you think, oh, this is perfect for, so and so, right? And then you wrap it up and you give it to them. I love that. That's also the hardest part for me, because I like to give the gift immediately. It's very hard for me to like wait. I want to I want to give it to them right away. But I love Halloween. Oops, I typed the wrong thing. So yeah, I'm excited for I wish I could say that it's going to be cooler weather and all that, but you guys know I'm in the Floridas. There is no cooler weather. We might go from 88 to 78, which is perfect for me. I'm not complaining. I'm good. Although sometimes I do miss like cooler weather where you can wear sweaters and stuff, because, before I lived in Florida, I lived in Texas, and Texas gets cold in the winter and the fall. And I do have some really cute fall and winter attire, but it is what it is. That's not how it is here. And so there we go. But I'm looking forward to it. To Halloween. There's some really good horror movies that are coming out, and I'm super excited for those. And for Halloween, I didn't get to do it last year because Allie and I were doing a lot of the Letitia stuff. We were getting the pretext calls, and then the calls while she was in jail, and the jail reports and all that stuff. So I didn't do it last year, but I am redoing the holiday or the Halloween horrors that I used to do when I first had my channel. But this year I'm doing a straight theme. Okay. I am talking about the true story behind the Conjuring universe, not Annabelle, because I already did that. But it will be the Perone family, which is the first Conjuring movie. It will be the Edinburgh Poltergeist, which is the second Conjuring movie. I did two videos already on the Amityville horror, but there's more to that story, and I always intended to do a third part. I just kind of like, paw prints on my heart. I was waiting for somebody to notice. Thank you. I appreciate that. Yes. I do so very much love the opening to Scooby-Doo that I went and found it and used it for my background. And I'm glad that you noticed. Thank you so much. So I'm going to combine the two parts that I've already done and then add the third part in. So that'll be the Amityville horror. And then I'm going to do the last movie in the Conjuring series so far, which is The Devil Made Me Do It. And because that's a very interesting case. And then the other one I'm doing, it's the movie just came out on Netflix in September, The Deliverance. It is the story about the family that lived in the demon house that Zach Baggins bought in Gary, Indiana. And there is a true story behind that one, of course. And so I'm going to do the true story behind that. So that is the plan. I also am starting a new Bedtime Books with Bendy series. I can't wait to tell you guys about it. I'm super excited about it. It's a book that I've read many, many times. And I want to share it with you guys. It is the book title is, And I Don't Want to Live This Life. It is a book about Nancy Spungen life, written by her mom. And for those that don't know, Nancy Spungen was the girlfriend of Sex Pistols bass player Sid Vicious. And in the end, he was charged with her murder. And so we're going to talk about that in Patreon. So be looking for that. It's a great book. It really is. I think that when it comes to that case, even though Nancy is the victim in that case, right? She's the one that died. She's really lost in her own case because there was so much hype around Sid Vicious. And don't get me wrong, I really am. I am a fan of Sid Vicious. I think that when he went out on his own, when he covered My Way, that's one of my favorite songs. But Something Else is like, I think I like that one better than even My Way. I just, and I am fascinated by Sid because he and Nancy lived such short lives that they were so chaotic and ended so sadly, and they died so young. And so, oh, Kathy, you'll have to wait, babe. You'll have to wait. I'm going to do like a teaser. You guys know I've been working on it this whole time. So I'll tell you guys in the teaser, I promise. Also, I'm going to start watching the Secret Lives of Mormon Wives. Tess suggested it to me, and I've just been busy and haven't had an opportunity, but I am going to do that. That'll be in Patreon. What else have I got planned? What else? Let me think. So that'll be that. There's something else. I'm totally the Menendez brothers. I have not forgotten. I've been gathering up things and watching things and taking notes and researching. And so, um, in between Sarah and and all the other things, I am going to cover the Menendez. There is one thing that I'm waiting for to come out, which comes out October 5th, and that is a documentary. It's on Netflix, and so I will just binge that, and I'll have to probably binge it once, then like watch it for real, for like really watch it a second time, because I always notice, I think that that's true of anybody though. You always notice things that you might have missed the second go around. And so, but I want to be thorough about this because, I've been watching a lot of things and listening to and doing my own research. And something that's interesting about the Menendez brothers case is that it's very polarizing. I think that there's a lot, most people feel very strongly one way or the other, right? And for me, I am always interested in the gray areas because I think sometimes, and I'm guilty of this myself, I think sometimes in true crime cases, we forget about the gray. And we see people really, the victims we see as one dimensional, and we see the perpetrators as one dimensional too sometimes. And I think we tend to forget that humans are multifaceted and they're capable of being many different things all at the same time. And so I want to approach the Menendez brothers case a little bit differently than I've seen being done. I want to bring you guys something that you haven't seen, or maybe something that you haven't considered, or just a different way of looking at things. So, yes, I want to do all of those things. So, I'm excited to do all of that. Did you, Nicholas? Nicholas says, yes, I listened to the Sarah Boone interrogation last night for the ntth time, and I heard new words again for the first time. LOL. Did you? What new words did you hear? I'm always interested in that, And I also think too, the first impression that I had of the Menendez brothers case, I was a teenager, and I've learned I've lived a life since then, and I've had children of my own, and, I've had and just life experience, and it changes your perspective on things when you go, at 15, 16 years old. Yeah, I'd been through some stuff, but, you know, the older you are, the more things you go through, right? So it changes your perspective on things. And I think I feel that way about Sarah as well. you know, I'm thinking a lot about it. And I was talking to Allie before the live started, and as it pertains to Sarah Boone. And I'm really guilty of this myself, especially in this case. I have focused so much of my coverage of this case on Sarah's shenanigans. And there have been many from the very beginning. I mean, the first thing is the 911 call, which we've all heard it. It's Sarah. What else can I say? It's very on brand for Boone. It's very Boone-esque, as it were. And so, and then the body cam footage, and then her interrogation, then the letters, and all the attorneys and all the things. And, I have not done anything about George, who George was, and I feel bad about that. And so I'm going to try and to correct that, because yes, her trial is coming up. Okay. And this is what I was talking about with Allie before I went live. You know, the trial, as much as you would think it would be the opposite, that it's actually about the victim, it's not. It's actually, in my opinion anyway, really about the perpetrator, right? Because the state has an obligation, they have a burden of proof that they must meet when it comes to um, their case. And I'm going to switch the backgrounds because now I think we've gotten enough of that effect. And quite honestly, the bats are kind of driving me nuts now. So I'm just going to switch it to a more tranquil background, I think, for this. Um, but um, the state has their burden of proof, and we'll, in the beginning of a trial, we'll hear about George a little bit, okay? And then should Sarah be convicted, found guilty, at the penalty phase, there will be a victim impact statement, and we'll hear a little bit about George, but we won't, it's not really about, it won't really be about, the trial's not really about George and who he is as a person. And so I am going to do some research and, try to have some things to talk about um, before we talk about the trial every day. We'll talk about George because I think it's important. And I'm so glad to see all of you guys here. I really am. I'm, I've been following this case for a very, very long time. And when I go live and I talk about this, I, um, I feel like I see how many of you how many in chat have been following it just as long as I have and are so interested in George and his family finally getting a measure of justice. Because I mean, let's be honest, it doesn't, regardless of the outcome of the trial, right? If Sarah is convicted of second degree murder and the sentencing is life without the possibility of parole, nothing is going to bring George back. And I that's, that stays with me. When I watch trials, especially when it's a case that I've followed for a very, very long time, followed all the things and have been waiting and waiting and waiting for the trial. And then the trial comes and I watch the trial, and then the person is convicted or, found guilty. And then the sentencing phase comes. To me, even the conviction is like a hollow victory for me. A lot of times, I remember covering Letitia Stauch's trial and her being found guilty. And, there was no joy that day, you know, even though I was relieved that she would never be out and free to hurt another child ever again and another family ever again. It was still sad because at the end of the day, Gannon lost his life in a horrible way, at the hands of somebody that he loved and he trusted. And I think there's something about a murder that occurs when the people know each other, especially when it is a parent child, that is particularly heinous. All murders are heinous, but there's something additionally evil about when about murder between people who know each other. Okay, the court is live. We're going there now. Hopefully all the audio issues are fixed. We'll see. Yes, Grace, he would have. And I got so tired at the end of my live. I'm so sorry, you guys. I wanted to mention that um, his Gannon would have been 16 um, on Sunday. right? Was it Sunday? I'm sorry. I feel awful like I should know that, but I've not had, I most people know, that between 2 and 4 PM my is Bindy's nap time, and, I didn't take a nap today, but I did still, um, get up at the same time I normally do, so I'm a little bit tired, and now I'm not now my brain is like, and this is where I need my brain the most, but anyway, it's not about me. Um, it's just sad when I think about what Letitia really did that day. You know, all the firsts that she robbed Gannon of: his first dance, his first sports game, to play sports, baseball, soccer, basketball, football. She robbed him of that. She robbed him of his goal to be a YouTube streamer. And she robbed us. See, that's what. See, this is what really. This is why I get so upset, when and what makes children's deaths, murders, so extra evil to me, because really what the person does is they rob the world of that child's potential. We have no idea what Gannon would have brought to the world. You know, she robbed him of the first time he gets to drive. She robbed him of prom, graduation, all the firsts, the first crush, you know? She robbed him of all of that, and then she robbed his family of seeing his first and being there for his first, and she robbed the world of his potential. And that's what's so sad about it. That's what makes it so, just everything, It's just sad. And she still takes no accountability. None. None. None at all. Not even her story isn't even about that Maria did it, Maria Sanchez. It's not even that anymore. Now she's changed it. She it's disgusting. Oh, thank goodness. I've never been so happy to see Mr. Owens in court in my whole life, because that means that he's not on Zoom, and we won't have to deal with Judge, can you hear me? Judge Crane it. Judge, can you hear me? Whew, whew, what a relief. Also, I know that the biggest, most important motion that we're going to deal with today is this motion to suppress. Okay. Um, the other motion that's set to be dealt with is this professional hair and makeup situation. It's an unusual motion. To allow her to have the ability to do her hair and makeup isn't unusual. The fact that they want to have somebody come in and do it for her is what's unusual. And I would imagine, unless somebody is volunteering to do it, it's going to if this is what she wants, who's going to pay for it? Okay. And but I'm given to understand through the docket on the Orange County clerk's docket that that part of the motion will be heard in chambers. And although I would love to it will be public at some point. Okay, I think. But I was listening to the lawyer, talk about that specific motion, and he made me laugh because he was talking about the makeup and, like, the mascara wand, although that's not what he called it, um, potentially being dangerous because she could try to harm herself, or, take it back to her cell and it would be contraband and hurt somebody else. And, he said maybe they could give her like some blush, and maybe she could apply it with her fingers, or lipstick and she could apply it with her fingers. And I don't really know how makeup works, which I just thought was, it was just kind of funny. It was just, a funny moment, and it tickled me a little bit, and it made me laugh, just for a second, because but he's right. Sarah is, I don't know what, and I agree with um who wrote this? Hold on. I just saw this comment. Hold on a minute. Welcome into everybody who's coming in. I just saw this comment. Maybe one of her female attorneys could help her. And I agree with that. I think that's a fantastic idea. And maybe that's why it's going to be held in chambers, because maybe maybe Mr. Owens has somebody in mind who has volunteered but doesn't want that out, in the public arena. And so that's why it's being held in chambers. I don't know. Edith, thank you for being a member for 3 months. I appreciate the support. The trial, yes, the trial starts on the 7th with jury selection. So once jury selection is done, obviously, then the part that we can watch begins. So I say, that's what I say. Send in MK with a bowl and a pair of scissors and call it good. That's my opinion too, Kimberly. I agree. Send in MK. Also, to Sarah, there were some depositions that occurred today of Sarah's psychiatrists, her 2 expert witnesses. They were deposed yesterday and today. And I also think, if I'm not, or tomorrow, one of them is tomorrow on the 3rd. Sarah had an evaluation today by the state's expert witness, their psychiatrist. So we'll see. Oh, Allie, you're the best. I love you. Yes, Jeffrey. Jeffrey says not only late, but strategically at 4:30, knowing the court wouldn't be able to review it. See, to me, and I agree with your earlier comment about it being a sign of disrespect to the court to have. We're talking about days late, okay? We're not talking about the deadline was 11:59 p.m. on September 27th, and it was filed at 9 a.m. on that Saturday, on the 28th, okay? We're not, which was a Saturday. We're not talking about like that. We're talking about days late. And, I was raised with, if you're on time, you're late. My parents raised me that you should be early, and that when you are late, it is, really late, like 5, 10, 15, 20 minutes late, right? It is a sign to people that you don't value or respect their time, that you think that they have nothing better to do with their time than wait for you. And it's rude. And that's the way I was raised. And so I feel like him filing the motion as late as he did was rude and disrespectful, 100%. And I would like to take a moment to thank the boss lady for being a member for 31 months. I believe that is just shy of how long I've had my channel. And I appreciate the support so much. All of your support, being here, sharing me out, coming in the chat and talking with me, and giving me the thumbs up, and just, I appreciate all the support all of you guys give me so much. I am so grateful for it. Thank you. Thank you, thank you, thank you. It's just ridiculous. I think Owens is disrespectful, and I think that to the court, I think filing the motion as late as it was disrespectful. And on top of it, yes, thank you, Jenny. Now, we've had this talk before, Mr. Camera Guy person. I don't know who's operating the camera. So camera person. We've talked about this before. Okay, we're here for a hearing. This is a courtroom. You're not filming the Blair Witch Project. Slow your roll, bruh. Please. Too much. Aw, Allie. Love you too, babe. You know I do. Let's see what Tanika has to say here. Tanika says, Owens has a lot of nerve turning things in late after his media tour on Friday. I hope Kranick lets him have it. I hope that I read that in the tone with which it was written, because that's how I interpreted the tone, because that's how I feel as well. It's just disrespectful. It's just very, very disrespectful. I think I need to get like a soundboard so that I can, I like that skit from Key and Peele, childish and insubordinate. I love that. So I want to get a little, I have some, I need to get some clips together to I think he's in for it too, Brad X. And yes, True Crime Boozer, Kranick has no time for nonsense. This is going to be good. I agree. I agree. Kranick, as patient as he is, as temperate as he has a very low tolerance for BS, and he runs a tight ship. I think he is uh, this has been drawn out far too long. There are people that were arrested, and I'm not talking about a month or two or three or four after Sarah Boone that have gone to trial already, although that's happened. I'm talking about people that were arrested years after Sarah and have gone to trial already. This has gone on long enough. It's time to stop it. It's time to get this show on the road and be done. I think. I agree. And I think that it's time. Thank you, Jeffrey. Jeffrey says, ooh, a soundboard would be great for you, Jen. You know so many clips of movies. I do. I do. So many. True Crime Boozer, I agree. I'm 54, True Crime Boozer says. When I grow up, I want to be like Judge Kranick. Me too. I'm 47. It's taken me almost the entire year of me being 47 to actually say the number 47. For the longest time, I told people, yes, my birthday is 47. I'm going to be 47 this year. I would not say 47. So, yeah, he is a good judge. He's the best judge, Tess Mack. You know who else I really liked was Judge Werner. I thought Judge Werner was very patient. I mean, when Letitia was, flipping the bird and making pew pew signs at at people on the stand and all the things, all the shenanigans that she was doing, and so he said, "Okay, I had you sitting at your own table. Clearly, you're not mature enough to sit by yourself, so I'm going to wedge you in between your two attorneys, and furthermore." Due to your insolence, I'm going to take away your swivel chair and the chair that leans back. You're going to be in an uncomfortable chair. You don't get the good chair. You act the fool. You lose good chair privileges. And then told her, if you don't cut it out, I'm going to chain you to the chair, which I thought was fantastic. Oh, I appreciate that, Nick. Nicholas says, I'm choosing this trial with Jen Liu over a Costco run on my day off. And I appreciate that. Although I will tell you, I do like a Costco run. But the best day I think to go on a Costco run is Saturday, because that's when they have all the samples. You can have an entire 5-course meal in Costco in samples alone on a Saturday. Yep. Let's see. Jenny says, is that clerk putting a blankie under her desk because she's cold? Y'all Florida people are continuing. Okay. Let me just say this, Jenny. Okay? You can't listen. Here's the thing about Florida. Okay? Florida, especially Central Florida, which is where this is taking place, is particularly muggy. Okay. And in order for them to have the right temperature in the courtroom to combat the humidity, they got to turn the AC down just a little lower. Okay. Which when you're inside, you tend to get a little, because after a while you acclimate and it becomes chilly. So, excuse me, hold on a minute. I'm coughing and I don't want to cough in the mic. Hold on. So then you get a little chilled. Now, cameraman person, you know this is going to cause issues later. Get the camera off of the sheriff who's doing whatever it is that he's doing on his computer. You know that's going to cause an issue. Don't do that, camera person. Okay. In my house, the way that the house has been remodeled, they took the garage and made it into a master bedroom. So when that happened, they had to rework the AC. So that room is the best room in the house, in my opinion, because obviously I'm a woman of a certain age and I'm going to leave it there, which is why all the fans in the house are at takeoff speed. But that room stays just the right temperature where you're chilly and you can overcome the hot flash, right? You still have it. But as you work through it, and sometimes can go days, weeks, sometimes without having one, right? It's the perfect temperature because I do need to be covered up. I don't know, I can't sleep without a cover. And I also need to be able to sleep with a cover and a fan on, and I need one of my feet to be out. I cannot have, you know, I can't do it. I just can't. And I forget what I was listening to the other day, just while we chit chat, because there's nothing really else for me to talk about. He did not. Did he? You got to be kidding, Jeffrey. I'm going to look. I was just over there. Let me go look. Let me just check this out. I was listening to a live the other day, and I forget what the subject matter was, but it made me think something about the dark. And I realized that I am 7 years old. And until I moved into this house has a remote control fan and light. I did still used to run and jump on the after I turned the light off, I used to run and jump. Oh, it was Allie's. It was Allie's. I was listening to her, and there was a case that she was talking about where this guy was at a car wash and harassing the women at the car wash, and he did it in another state, and he would hide under their car and grab their ankle, and how creepy that was. And it made me think about how I used to run and jump onto the bed until I had the remote control to turn the light off because I don't care what anybody says. Underneath the bed still creeps me out. Okay, he did. Owens did file something. He did file another motion to suppress. It's the second amended motion to suppress defendant statements at OSCO. On September 30th, defendant filed an amended motion to suppress statements at OCSO. Defendant reiterates the facts and arguments outlined in the previous filed motion, and in addition, why do I squint? Why do I try to? Why can't I just should make this bigger. In addition, avers the following. Both the United argument and citation of authority. Let me just share this tab instead. Both the United States and Florida Constitution provide that no person shall be compelled to be a witness against themselves in any criminal matter. See U.S. Constitution Amendment v. Article this. Where a defendant is subject to custodial interrogation, he must be administered the proper procedural safeguards, commonly known as Miranda warnings. See Miranda versus Arizona. In the seminal Miranda versus Arizona decision, the Supreme Court enunciated this bright line rule to guard against compulsion and coercive nature and atmosphere associated with interrogation to, quote, assure that the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. 5, and while the defendant may waive effectuation of these rights, such waiver must be made voluntarily, knowingly, and intelligently. The court must make a case-by-case determination based on the totality the totality. What's going on? Let me see what they're doing. Hold on. Nothing yet, you guys. Working on audio, but they do it really abruptly and it's in my ear and it hurt. Sorry about that. Sorry. The court must make a case-by-case determination based upon the totality of the circumstances as to whether the waiver was constitutionally sufficient. Therefore, until the Miranda warning and waiver are demonstrated by the prosecution, no evidence obtained as a result of interrogation can be used against the defendant. Defendant was in custody for purposes of Miranda. Custody encompasses not only formal arrest, but any restraint on freedom of movement of the degree associated with formal arrest. See Taylor versus State. A person is in custody if a reasonable person placed in the same position would believe that his or her freedom of action was curtailed to a degree associated with actual arrest. Here it is uncontroverted. Defendant was in custody for purposes of Miranda. On February 25th, 2020, defendant arrived at the OCSO where she was directed to an enclosed interrogation room. Therein, she was surrounded by 2 detectives, Ketzel and Lowen. Furthermore, Lowen's firearm was visible on his waist throughout the interrogation. Therefore, it was reasonable for the defendant to believe she was not free to leave at that time. Defendant was subjected to interrogation for purposes of Miranda. Interrogation is any questions or actions by a state agent that is likely to elicit an incriminating response. 10, in the instant matter, defendant was directed to an interrogation room where she was subjected to investigative questioning for 2 hours. It is undisputed that the line of questioning exhibited by both detectives was likely to elicit incriminating responses. Therefore, this court should find the defendant was subject to interrogation for the purposes of Miranda. 3, the state has not proven that the waiver was made knowingly, voluntarily, and intelligently based on the totality of the circumstances. Oh boy. A court must determine based on the totality of the circumstances whether a voluntary and intelligent waiver of Miranda warnings has been made. In making this determination, the factors considered by a court include the, quote, background experience and conduct of the accused, who had been arrested before, and her conduct. Let's talk about her conduct, shall we? Let's talk about her conduct for a moment, okay? All right. What was her conduct? Well, we watched her interrogation video the other night. In particular, we scrolled through. We didn't watch the very first beginning of it, probably the first 30 minutes or so, because we've covered that, several times on this channel. And I wanted to get to the part where she's shown the video and all the things, right? So that's exactly what we did. And recall that at no time that Sarah does ask when her phone will be returned. Now, she's answered by the detectives. And the detective, Lowen, he says, who knows? It's at the state crime. It's at the state crime lab. It could be, one day, 11, or it could be 11 billion days. That's not exactly what he said verbatim. It's not a direct quote, but you take my meaning. Okay. So that happened, right? Now, what did Sarah do? What was her conduct? Was her conduct to say, back the milk truck up, hold the phone? I was under the impression that I was coming down here to get my phone. No, she did not. She said, what did she say? Okay, that's fine. That's what she said. Also, her conduct. As the interrogation progressed, there came a point where they were really at an impasse with Sarah. She was frustrated, they were frustrated, but Sarah was going to make one last point. And in doing so, what did Sarah do? Her last point was she was very emphatic, and so she stood up. What did the detective do? The detective, all he said was, sit down, which is for his safety and his partner's safety. Did Sarah stand up and say, I'm leaving? No. Did she stand up with the purposes of leaving? No. She stood up to make a point. Her behavior is evident. She gave, in my opinion, she gave that interrogation, she waived her rights, her right to remain silent and her right to have an attorney present during questioning, freely, knowingly, and voluntarily, period. That's all he said was sit down, sit back down, ma'am. He did not tell her she couldn't leave. She didn't, at no time did she try to leave. Okay. So he goes on to continue, we've read this already. So I'm going to stop sharing this. I'm going to go over here. I'm going to share this tab instead because Sarah is looking at paperwork. She's uncuffed, but she's in jail clothes. So here we go. And she was making a weird moment. I don't know if you guys caught that at the moment that that it switched over from one tab to the other. So let me just show you what she was doing. I'm not sure what that motion is. I don't know if today she is the chicken and she's pecking. I'm not exactly sure what that was about. If she's coughing, I don't know. I do not know. Oh, you want to know what time that was filed? I will be happy to tell you. Let me scroll up. Brace yourselves. 2:35 and 30 seconds. Today at 2:35. And I know this because what did we start out doing? We started out doing we started out on the docket. Now, the state has filed a response. Please let me refresh to see if that has been uploaded, and it has. Here is the state's response. I'm gonna leave it on Sarah because I'm not sure if she's still pecking or what she's doing, but that's far more interesting, in my opinion, to watch visually than just this paperwork, right? So, and I'm going to read it to you. So here we go. The defendant, this is their response to defendant's case law submitted on September 30th, 2024, regarding the motion to suppress filed on December 24th, 2024. Here we go. The defendant filed a motion to suppress statements on September 24th, 2024, without citing any case law to support her position. On September 26th, the defendant submitted cases to the court regarding her motion. On September 30th, the defendant has filed additional case law with the court. These cases appear to involve issues outside the four corners of her motion to suppress statements. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. State versus Christmas. Vera versus State is the first of these cases. In that case, while not actually having video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, alleging that they did. The detectives in this case never said they had evidence they did not have, and the defendant declined viewing the video she made while the decedent was in the suitcase asking to be let out. There was never any threat of the police taking any action or inaction based upon what she told them. This case is in opposite.
Madam Clerk, I'm ready when you are.
Steve Ketchner on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion?
Yes, sir.
Are you ready to proceed on that today?
Yes, sir.
Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got 2 detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card? Or
Yeah, if you look
Fine.
in the very back, if you look in the very back,
Okay.
you see the Miranda card, the last page, and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes. I also have reviewed the 2-hour and 6-minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification because DVD, emergency copy, it's the body worn camera.
And I have reviewed all of those in advance of today's hearing. Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1. Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle. Chelsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide detective.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Lowen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
You recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time I was in a unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, of course not.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. And, so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house. But
Prior to that, had she been detained and requested not to leave the scene?
all right, one more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. but due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or
And-
maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know, there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car? Or
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're gonna go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no,
Okay.
but I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection to relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
Remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant And I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about.
Hold on. I can't let him have the last bite at the apple without me remarking on the comment made by the prosecutor asking that witnesses be referred to by their surnames, and Owens turning around, giving him the stank eye, and just to be sure that the attorney was aware that it is he's giving the stank eye to, he pulled those glasses off. I couldn't let that go. All right, let's keep going.
The totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's
Okay.
fine. You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is.
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read from. Continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there's that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
If her card doesn't have the 9th question, then what's up with the policy there, Mr. Owens? Apparently the policy doesn't.
When y'all took her
Require
phone,
the 9th
detective,
question?
Did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines. Yeah.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I did probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to Jorge Torres from the autopsy?
Objection relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone.
Objection relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection to the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection irrelevant.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree,
Sorry about that, Jacob.
prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
She's in a green chair right now. Owens, what say you?
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection, proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled is relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
MK, pay attention when the
Do
camera
you
whips
recall,
around for
again,
Sarah's
omitting
due. Inspirations.
question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
The only thing, and y'all, hold on a second. Let me just pause this really quickly to tell y'all. I have analyzed, enhanced, amplified, done all the auditory tricks I know to do with that video where you can hear them just before they enter the door. The only thing that the detective asked, she didn't even ask her anything. What she said was, just let me know if you need any more water or anything, okay? That's what she said. So, Owens, cut the crap. What are you flipping through, bruh? You weren't prepared? What are you doing, Mr. Owens? Were you looking through the J.C. Penney catalog just to see? I know you got Sarah's measurements. Are you looking at trial attire for Miss Boone? What's happening here? Come on, bruh.
You may.
Oh, for the love of corn. Come on, get this audio together.
Yes, this is our waivers and affidavits.
Is that a filled out
It's filled out by me, but there's something highlighted that I did not do.
And was that form filled out as it relates to Sarah Boone?
We're talking about just this top, right? Okay, I'm sorry. It does it what?
This is a fantastic profile picture. Sidebar.
In case, yes.
Is that her signature or not?
Yes.
Did you see her sign it?
Yes.
Is that your signature below?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
And that is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, no.
Okay. You would agree that there's 9 questions on that one?
Yes.
I don't recall him asking to approach Tanika. However, the audio, as you are all
Same
well
objection to the
aware of,
relevance.
is
As far as it
cockhouse.
being a consent to search her
I could've
phone,
missed
we're
it.
not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you.
If you understand
Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell,
Yeah.
and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
Oh,
She
all
has a
right. Let
duty.
me mute.
To read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think.
Listen, I'm going to leave it up on because his audio is being picked up so you can see what he's saying. But I have to say, I didn't hear nothing he just said other than she's going to testify. That's all I heard.
Should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351 Southern Third 197 and Owens 41 Southern Third 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights, you would agree the situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
I really do think they're going to get these audio issues worked out for trial. I mean, and also she clearly was free to leave because she got up out of that car, right? She wasn't arrested, was she? Let me ask you this, Mr. Owens. Did Sarah at any point in that interrogation video on the
That's all the questions
25th
I have at this time.
ask
Any redirect?
if she was free to
All right,
leave?
can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you.
Oh my God.
State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
Oh my God. Come on, bro. Are you going to call her or what? What's happening?
Just that one.
What is it that's been marked as Defense Exhibit B?
I have to give it up to Sarah Boone. She does have excellent posture. Sarah, Tracy, he said Sarah's going to testify. He pointed to
objection?
her and said she's going to testify.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you.
Kimberly said she.
Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument?
Same argument.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
If she wasn't sure, she could have asked and she could have remained silent. Remember, Sarah excels at everything that she does, and she definitely excelled at catching a murder charge. Way to be, Sarah. I mean, I don't know what else to say. This is ridiculous. Oh, here we go.
And
Here
Mr.
we
Owens,
go.
you had one additional exhibit as well?
This is
Is Sarah the exhibit?
policy of the Sheriff's Department.
This right here, it's the video on her phone.
Do you know what
that's
page
damning, not the
specifically
interview.
those
Hold on.
policies are on?
Let me turn this down. I don't want to be rude to the judge. Unlike Owens, I have couth. It's the video on her phone that is damning, not the interview. They would have had that no matter
Is it,
what
beginning of paragraph 4,
with the
waiver of
search warrant.
constitutional rights?
Absolutely.
Yes,
Her statements just made things worse. She comes across worse. That's it. She didn't, it's not like her statements gave them the evidence they needed to arrest her. They already had an arrest warrant for her based on those videos. Mr. Owens.
Okay, I've read pages 14 and 15.
all right, Judge, and then you go to 13 of 28,
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
I have no idea what he's
And then
doing,
it goes
Roberta,
on to the next
wasting time
page.
and getting on my nerves.
14 of 28. Specifically 2A on 14.
Resistance is futile. Even Star Trek knows this. Right. Also from Star Trek, the needs of the many outweigh the needs of the few, Owens. And we need to put your client up there on the stand. The needs of the many want to see this. You know what, Jacob?
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right.
We
I'm
don't
gonna
know if
overrule
she
the objection as to
attempted.
relevance as to what was pre-marked as composite C, and that'll be received
delete
into
the
evidence.
videos.
Over objection is states
We don't
1.
know that actually.
I'm sorry, defense is 1.
Hurry up and put Sarah on the stand. MK in the chat here needs hairdressing ideas.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Finally.
Ms. Boone can approach the podium.
Oh, I'm so glad we're all enjoying
She
this
was previous
together,
this
you
morning. Forgive me.
guys. Thank you for being here. This is what we've been waiting for.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her.
And here we go.
Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
You're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding Jorge Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation was the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it.
Okay.
Objection sustained and it's stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then, were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that OCSO asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Objection, calls for she's five.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Kopsel.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Kopsel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Coatsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
Did I call for a yes or no? She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Copsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone.
All right. And so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No,
Okay. So directly off the elevator and walked into the interrogation room.
correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes,
We've all watched the video. Spoiler
You
alert.
recall that happening.
yes,
Did that refresh your memory watching the video?
yes,
Do you recall her saying that she had received the autopsy?
yes,
Sarah can be coached, y'all.
Do you recall her saying, I want to
watching.
read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
And she also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way,
Were you trying to cooperate?
in every way,
Were you polite with them?
very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes,
And then you said normal protocol.
yes,
Is that what she had said the day before?
what do you mean?
Normal protocol.
Yes,
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had,
Yes,
but you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
Did you ever hush? Did you ever stop speaking? Did you ever ask for an attorney? Did you ever ask if you could leave? No.
The way that she acted, the things that she said, the fact that they had your phone, Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial
Okay,
interrogation.
but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to whether or not.
She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
Have
That's
you
all the
ever been
questions.
arrested before?
Any cross-examination?
Stop it. Get him. Get her, state.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct?
Mimosas.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then,
Are you
Did alcohol affect my conversation with her?
there's a jury instruction that
Are you
says
drunk
a
now?
witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I believe.
I know that she said she didn't know what it.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
You're so welcome, Tiffany.
But
Thank
I
you
agree
guys
with
for
the
being here.
impeachment About being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
Also, I would just like to take a moment to remind everybody that Sarah has done an extensive letter writing campaign in which she added up the days, hours, and minutes of her incarceration, as well as any communication or lack thereof with former attorneys. I pass the witness.
2020.
Yes,
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Let's go, Mr. O. Come on, bruh. You know know how this works. It's your turn. Be prepared. Let's go. Yeah, you there, Mr. Owens at the defense table. He needs a trapper keeper. This wouldn't happen if he had a trapper keeper. Be all organized.
Judge, my understanding of the law regarding Miranda,
Hey, Earth. good
first
to see you
issue is,
again.
was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement,
Y'all's
after-
commentary is the best.
they
Y'all's
get
comments are just
a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions. Go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques,
Sarah.
when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick.
Well,
That
thank goodness none of that happens.
Right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you.
Thank you so
We just
much.
have to.
That's not illegal.
Before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you but you have a right to remain silent.
But the statement of "we have to read you the rights" was made before "we have to talk to you."
Tell it, Judge.
So your argument transposes those two things
Thank you.
chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses.
That's your story.
A traumatic event. She lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone.
What?
And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other.
Oh, this is a
That's
lame
improper.
argument.
It's illegal. It's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the 9th question.
Oh my God, the 9th question. I'm in the 9th circle of hell listening to this. This
If you
is
think about it, okay, you got a right to remain silent, you got a right to a lawyer.
hoochie mama activity I might have did
Those
when
3
I
or
was
4
younger.
questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kupsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kupsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
into the record.
Yes, of course. They were
Unlike-
pre-marked.
Hold on a minute.
Moving now to
Hold on a minute. I got to say something. First of all, you see how it's done, Mr. Owens? You see the judge? It's a court holiday, but Judge Kranick will be here working, unlike you, who was supposed to have turned this motion in by September 27th, 2024 at 11:59 p.m. You were late, but you made it to be on time on Vinnie Politan's panel, didn't you? Mm-hmm. Sure did. By the way, I would like to file a motion to suppress my memory of that entire lame-ass argument you just gave, Mr. Owens. All right, here we go.
the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Early birthday, Anna.
And Judge, I just want clarification, but she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
So
What's the fucking
only time
point?
is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk,
God.
but we believe it's not necessary.
Hold the phone. Hold the phone. Back the milk truck completely. Is this your first day, Owens? Is this your first day in a courtroom ever, or to prepare for a trial? Do you not realize that it's been done 11 billion times? And what they do is they put the defendant in the witness box before they bring the jury in. Are you new? I'm sorry, y'all. He has just got me irritated. I am irritated.
And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
No, Owens, let me tell you what they're going to do. It's going to be completely different when you walk into the courtroom on Monday. They're going to feng shui the shit out of that courtroom. Everything that you see as it is now is going to be somewhere else. What the fuck?
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
There are four
Anything
other
further as
attorneys
to that issue?
who would differ.
I don't believe that's case law authority. on
Doesn't
the
know
issue.
how to
I
behave.
believe so.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to provide, get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her in the morning each day of trial.
Okay.
With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right
Where?
to hair, cosmetics, civilian clothing without restraints for trial. Just
What
the arguments in there.
what case law did you cite about hair and makeup? Lori Vallow came to trial with her
And
hair
the
did.
Estelle
and-
case that you spoke
hold on a
to,
minute.
you cited to, spoke to being
Excuse me, Your Honor. I don't want to be rude, but Lori Vallow came to trial every single day with her hairs did, and she used hot Cheeto dust for her lipstick and her blush. If Lori can do it, Boone can do it. The end.
dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I'm done.
I just think it's, it's just part of a fair trial.
Oh,
The other
okay.
problem is it's contraband.
Mm-hmm.
That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now.
get
and the
to
other
it.
is a consultant, but
Uh-huh.
they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning.
If she don't
So
have,
I'll
she don't
pleas
have a
every
full
morning and other
makeup,
matters,
a
'cause
full
court still has
face?
other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same
Okay.
analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yes. Yes.
Hold on a minute. I got to say something. Well, let me play it and just turn it down. Boone, if I were you, I would get me some Coca-Cola from commissary, and I would use those. Drink the Coke. Okay.
So corrections in the
shower
Orange
and
County
roll
Sheriff's
your
Office
hair.
have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
It's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay. Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, and said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing the enlisting I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office
Thanks
of the
for
State
being
Attorney.
here,
And
Jacob.
the state is seeking a protective order on the grounds that it's
Have a good
work
day at
product,
work.
opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that Jorge Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their requests, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
Yeah.
How would that not be protected by work product?
Well,
to whether or not it was a
if it comes
decision.
out, if it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do.
So what's
So
the
just
point?
that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it. And their
That's what
power
you
and
want them
authority
to
do so,
testify to.
not
They
the
didn't
victims.
listen to Sarah. Sarah
Okay.
wasn't the boss of them. I
Responsive.
got it. Okay.
Judge, that's opinion work product. That is absolutely protected. I don't
Better get you
understand why
some
he
Coke
believes
cans and hot
that
Cheetos, that's
arrests
Sarah.
and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we're moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case.
Oh my
That is
God. I
opinion
told
work
y'all
product.
that's what
And
she
if they wanna
wanted.
get-
He wanted.
Public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. The defendants had these things that are getting dropped on the state. for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Holy guacamole.
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just.
Well, I'll
that
explain
they
it in a
have the
minute,
ultimate
Melanie.
power to
Let him,
dismiss, not
I want to hear what he has to say, and then I'll explain it.
why
I'll
they
explain it, you
chose
guys.
to drop
Let me just listen.
3 cases against Jorge Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
All right.
Judge, and then on Dr. Brandon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, Paul's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brandon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that. So,
Go ahead, I'm sorry.
those 2 things are the only 2 things that I believe we had left prior to jury selection on Monday.
Okay. If any motions
Fantastic.
are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all
I
of these
will,
hearings no
Crystal.
later
Give
than
me
the close of
just a
business,
second.
hopefully earlier than that by tomorrow. On Monday morning, state if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and then we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow. But based on what we witnessed this afternoon, it's the state's position that we're going to need to file.
Oh, shit.
Okay, all right, appreciate it. All right, thank you all very much. We'll address scheduling of any motions on Monday.
We
But
are.
it may
I'm
be a
going to rewind
circumstance
it.
whereas
Just
the
I
court
want to
had
hear the
identified
last of
earlier
this,
that
and
we're
then
just
I'll
gonna be
rewind
looking
it.
at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right, thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
All right, I'm going to rewind it. Give me just a sec.
Yes. Yes.
Okay. So the next thing that they're going to talk about after the makeup situation, okay, is this protective order that the state filed, okay? So what Mr. Owens wanted to do, okay, was he wanted to have some people from the state's attorney's office testify that even though Sarah Boone asked them to drop the charges against George in other other domestic violence cases, okay, that it's not, it wasn't their decision to drop the case, not to prosecute, was not based on Sarah's request. What that had in his argument is, which is ridiculous, they don't need to testify for this. His argument is that her going to these people and saying she doesn't want him prosecuted is a pattern of a person who has battered spouse syndrome. That's what his argument is. Okay. Now, what the defense or what the state is saying is that's ridiculous. They don't need to testify to that, and that's not what he's up to. And then, okay, so that's what he's trying. That's what Mr. J is saying. So let's get to that part really quick. Hold on, because this is the makeup that nobody cares about.
Custodian of records, Orange County, Office of State Attorney, Domestic Violence Supervisor for the Office of the State Attorney.
That was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses. Custodian of records, Orange County, Office of State Attorney, Domestic Violence Supervisor for the Office of the State Attorney, Victim Advocate Supervisor for the Office of the State Attorney, and Misdemeanor Supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion
Have a good
product,
day, Tanika. Thank you
and
for being here,
requiring
babe.
prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know,
So the state's argument is, listen, we don't want our prosecutors getting up here and telling in open court what they use to determine whether or not they're going to prosecute a case. Okay. Because in essence, that would be giving like a guidebook on how not to get prosecuted. Okay. Now, we're going to skip over Owens because I just explained everything that Owens said. And I want to hear what Mr. J has to say, because what he says is important. All right, here we go.
I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim.
Hold on, I want to address this comment really quick. Okay, so Lil Red says, I believe it's a pattern, but she does fit that. Okay, that's not what they're, maybe I'm behind it. Maybe I'm behind in comments. But the issue here is who Mr. Owens wants to put on the stand and what testimony he intends to elicit from them in an effort to prove battered spouse syndrome. Okay. And the state is saying, no, no, no. They don't need to get up there and testify and explain why they decided not to prosecute George for domestic violence. And that's what is at the crux of the issue. Owens wants these witnesses to get up there and explain their process by which they decide whether they're going to prosecute somebody or not prosecute somebody. And that has zero to do with battered spouse syndrome. Sarah simply asking them to drop the charges, her asking has zero bearing on whether or not they would prosecute George. Period. She has no bearing on that. Okay. So there's no reason for these people to get up there and have to testify and explain why they chose not to prosecute George. That's what the issue is, not whether or not she has battered spouse syndrome.
Victim has committed, or reputation evidence.
So let me rewind
that can
this.
come in from anybody, and it is relevant. But that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those.
See, okay, so Melanie, after this part, wants to know, did she really ask for literal makeup? And if so, did they approve that? She did ask for literal makeup, and they did not approve it. It's not about her entire history of her and George. That's coming in anyway. They don't need to have people from the state's attorney's office testify to that. That's the point. All right, let's keep going. And they were served at the jail.
Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021.
Okay, and now the second issue here is the issue of reciprocal discovery. They have had in their possession since 2021 her medical records. Billy Lane got them, okay? Which means if Billy had them, Mr. Owens had them, and he's had them since he took this case, which was when, class? August 30th, 2024. And they're just now, and the state is just now getting them, okay? Now, we'll continue. That's that issue.
So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways.
You see, the evidence is going to come in anyway that she requested to have those cases dropped. What he's objecting to is the people that they've called. It's protected under work product. The state does not have to disclose why or how decisions are made about who they will prosecute and who they will not prosecute. And so I'm not saying okay, hold on. Let me just take a second. All right. What the state is arguing is the testimony that Mr. Owens wants to elicit from these specific witnesses has no bearing on the issue of a battered spouse defense. What he's trying to get these specific witnesses to tell is how they based their decision on whether or not to prosecute Jorge Torres for domestic violence. Those conversations are privileged and they are protected under worked product opinion. So therefore, the state is arguing he doesn't need to speak to those witnesses. All of the past arrests will come in anyway. He doesn't need to get these people on the stand who are victims, advocates, who are prosecutors, and give abusers a roadmap to not get prosecuted. That's what he's asking for. That's what Owens is asking. He wants them to get up there and testify to how it is they make a determination about whether or not to prosecute a specific person for domestic violence. In essence, giving future abusers a roadmap to avoid prosecution. They will know what they look for and why they. So if this deal is that it would make it difficult for them to prosecute George, if Sarah refused to testify and they admit that's why they didn't prosecute her, what's the next abuser going to do? The next abuser is going to intimidate a witness, their victim, into not testifying so that the case will be dropped. That's the point. That's what's at stake here. This has nothing to do with whether or not she has battered spouse syndrome. That's it. That's it. I'm not even arguing whether she does or she doesn't. I'm not qualified to diagnose her. He does not need that evidence. He does not need those witnesses to come in and testify in order to support Sarah Sarah going to the prosecutors and asking them to drop the case would come in. He doesn't need the prosecutors to testify that she did that and why they chose not to prosecute as evidence of a pattern of behavior that people who have battered spouse syndrome exhibit. That's the point. I think, this is my personal opinion. I'm not qualified to diagnose, but I'll tell you what I think. I think there's a difference between a battered spouse and a battered spouse syndrome. I think that Sarah was battered. I think that George was battered. I think they battered each other. That's what I think. Do I think she has battered spouse syndrome? There's a lot of things that she does that don't line up with some of the things that a battered spouse would do, but I'm not qualified to make that determination. And so I am very interested in hearing what her witness has to say. Now, we're going to continue to listen to this, and there's apparently even an issue with her expert witness. So let's keep going.
Through her phone extraction, she is immediately working to bail.
Hold on, I want to rewind this a little bit.
It's up to defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in. But
now did y'all hear that? Because, and this is why it's important that I wanted to know what you guys think about this. Because now somebody asked, I don't know, a couple of lives ago, who knows now, my brain is mush at this point, but it was asked, what other evidence could there be out there that we don't know about? Well, there you go. Right there. There is more evidence on her phone that we didn't know about. That includes, allegedly, apparently, a video of Sarah coaching George on how not to prosecute. And guess what? The one time Sarah was charged for battery, guess what happened? She wasn't prosecuted. That's why that's important, because if the argument is, what's interesting though, is that we don't, at this point, just based on what we heard today, I don't know what else the defense has. I'm just basing this solely on what we're hearing in this moment, just to be clear. Is there a video on Sarah's phone of George coaching Sarah on how not to prosecute? I'm curious. I would be curious about that.
But it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against Jorge Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
You'll have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's.
Okay, so what he's saying there is if all Dr. Brannon is coming in to explain is what battered spouse syndrome is, it would be duplicative and unnecessary because Dr. Harper is qualified to do that. So there's no reason to have a witness to just come in and explain an additional expert witness who is to just come in and explain the battered spouse syndrome when the actual forensic psychiatrist that evaluated Sarah can explain the same thing. Welcome in, Northwest. Sorry you found the channel when I was being super passionate and frustrated. I'm sorry. Oh, Tanika's 2 cents sent you. Well, tell her thank you for me. She was in here earlier. She left. I think she had to go pick somebody up. But yeah, thank you for being here. I'm glad that you came over. Okay. Now the next part is important. Okay, here we go.
My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, All's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead. I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, state if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion to eliminate.
Okay, all right, appreciate it.
Okay. Now, whew, here's the deal. This was something that was alluded to when Sarah Boone was on the stand. Okay. Evidently, Miss Boone over here has changed her story a bit. And what I'm thinking it is what I think it might have something to do with would be her alcohol. Sarah's real, as we learned from her interrogation video, Sarah is real sometimey when it comes to talking about how much she's had to drink, whether she's inebriated or drunk, which she does use the term, the Latin term for sound mind or yeah, wits about you. But somehow the distinction between impaired and what was the other word? Impaired and I think he said inebriated. Anyway, she didn't understand the distinction, which there really isn't. Basically, he's asking her, listen, when you drank on Sunday night and when you woke up on Monday morning before you called 911, were you still drunk? Impaired. Inebriated and impaired, I think is whatever, however he used it. But she didn't understand that distinction. Evidently, that is different than something that she said to the state's expert who evaluated her. And if that is, and he's going to see how the depositions go as far as the state's expert witness or who just evaluated Sarah. But my thinking is that the state, and likely the state's expert, does not think that the battered spouse applies, and they're going to file a motion to that effect. And of course, with the state, they are always citing the case law and they give specific examples. So I can hardly wait for those motions to be filed. And I think that, I will stay on top of it. As you know, I keep the Orange County Clerk's website browser open and I constantly refresh. Yes, Hazel Eyes, I will absolutely be covering this trial live. Okay. How I'm going to do it is I will, we'll have our morning session. We'll take an hour for lunch, just like the court does. Then I will have all of these all scheduled out ahead of time. Okay. And then we'll take an hour off, come back when they return from lunch and continue through until the end of the day. I will do that every single day that court is in session. But I do want to be cognizant and fair to the to people who work during the day and who who won't be able to watch the trial with us during the day. So I think I'll do is maybe like Tuesdays and Thursdays and Saturdays maybe, or something like that. I'll go live at night to do like a recap of the trial day for those people so that jury selection. Oh, I need to look into how Florida does it. My understanding is that there are times when jury selection can be streamed, like you can hear some of the questions that are asked, but I don't know. I'll find out if they are going to stream it. I do know that Court TV, I think, has a stream scheduled for the start of the trial, which is October 7th at, I think they have their live scheduled for 8 o'clock. So I will keep an eye out on that and I will find out for you guys. And you can always make sure you're subscribed and turn your notifications on and watch my community tab because I will keep you guys updated there. I think that this is going to be one hell of a trial. I think if we think that we have seen all the things that the state has against Sarah Boone, I don't think we have. I think that Mr. J talking about that video on the phone, we didn't know about that. I had no idea about that, and that was a surprise. So if there's one thing, there's probably more. Oh, Rachel. Tess says we so appreciate you covering the trial daily. You're welcome, babe. And here and Rachel, yeah, the word case studies. Thank you for existing. Well, I appreciate that. Thank you for appreciating that I exist and that I cover this trial. Listen, I know that there are a lot of you guys who have been watching this case since the beginning. Some of you guys have been with me since the beginning. But I know that the majority of you guys, especially if you're hanging on, so long after the court has been in recess, that you're invested in this. And at this point, dadgummit, we are owed this trial. We have been teased. We've been told the trial is coming only to look and see, and boom. No, it's not happening because another dadgum attorney has had enough of Sarah's, and I don't blame them. I don't. They've filed another motion to withdraw because they've had all they can stand from Sarah and they can't stand no more. And I don't blame them at all. Like I was losing my patience and I'm not even in the courtroom. Charlie asks, Jenmu, how long is the trial to last? I've heard anywhere from 2 to 3 weeks. So, yeah, the 9th. Owens wants 3 weeks until the 9th question mystery gets solved. Look here. I'm in the damn 9th circle of hell listening to that argument that he made. I'm surely being punished from some hoochie mama activity I did when I was young. And that's why y'all are here too, huh? Y'all did some hoochie mama stuff back in the day too. And now we're all being punished. Oh my gosh. There's no way. Okay. I wanted to talk. There is something I do want to talk about really quickly before I let you guys go. And I want, please hang out because I fixed the outro and I really want you guys to see it. All right. So there's a couple of things I want to talk about. One is Detective Ketzel. I'll get it by the time trial is starting. Okay. I hope there were a few times when I understood why she was frustrated, the detective. I did, because basically what what Owens is saying is not only did you not do your job correctly, you violated the Constitution, which is something they're sworn to uphold. Yeah, it's kind of a big deal. And so I understand why she was defensive. Excuse me. I hope that the state, I'm sure she's experienced enough. She's probably testified more than once. And so she tones that down just a little bit for the trial, because sometimes that comes across a certain way to the jury and it's better if it doesn't. Okay. But I understand the jury won't understand why she's being defensive. They'll only see what they see in that moment. That's all. I think she should keep her hair exactly how she had it today. It was gorgeous. Now, the other thing, excuse me, let me take a little drink. I got a little boisterous earlier and boisterous and boisterous and vociferous. And now I'm a little parched. So with Sarah, I think one thing that a huge takeaway from this afternoon's hearing is we got a glimpse at what we could be looking at if Sarah Boone takes the stand. And I have a feeling, it's today? Yeah, today's Wednesday. He met with Sarah Monday. He said he was going to meet with her Monday. I have a feeling that Sarah Boone has been coached, and I'm not saying anything negative about that. I'm not judging that at all. Coached, prepared, whatever verbiage you want to use, it all means the same thing. That is an attorney's job. His job, her job is to prepare their client for testimony. And I think if you're going to use this kind of defense, she's going to need to testify. The jury's going to expect it. And so I think if we've learned anything today, it might be that Mr. Owens might just be the Sarah Boone whisperer. However, that's asking questions on direct. I'm curious to see how she fares on cross-examination. And so it's always a dicey proposition, but we know that I think that what Mr. J did this afternoon with questioning her is this is a hearing. It's very different from the trial. And if I were Jay, Mr. J, what I would do is he never took a nasty or snarky tone with her or anything like that. He simply attempted to explain the question or re-ask it in a different way. And I think there's going to come a point with Sarah where the real Sarah is going to come out when she gets frustrated. She understands the question, trust and believe she understood what he was asking. She didn't want to answer. And that's what she does. I noticed that in the interrogation, that when she is asked a question that she doesn't want to answer, she just repeats the question or repeats parts of words or, parts of the question. But I do think that she will get to the point where she snaps. She gets frustrated. And the real Sarah comes out, and the jury is going to see that. So I want to thank you guys all for hanging in there with me. I appreciate it. I know that this is a highly anticipated trial, and I'm really glad that we got to. If I was going to watch Boone haul her cookies up on the stand, I can think of no other place I'd rather be. And no other people I'd rather be with than you guys watching Sarah Boone take that stand today. Okay. I was not prepared. So thank you. And I really do hope that they get the audio situation worked out and the camera person stops giving us the dadgum Blair Witch. This is a trial, not the Blair Witch. All right. So I want to thank you guys. I'm going to play my outro. And y'all let me know what you think, okay? Just let me know. If you don't want to watch it all the way through or you do, whatever, let me know in the comments later or whatever. Thank you guys so much for being here. I'm tired. Have a great rest of your night, and I will see y'all later. Bye. Hold on a second. What the hell? That's not what I wanted to do. Hold on a second. How do you do this? I did it before. Hold on. Let me figure out how to do it. Oh, wait, I remember now. Now I got it. Here we go.
Cause it's Friday, you ain't got no job, and you ain't got shit to do.
2 minutes later.
We all go a little mad sometimes.